Some changes have been made to the illegal immigration policy in Prince William County.
The Prince William County Board of Supervisors chairman says last night's action by the board actually strengthens and expands the county's illegal immigration laws.
It actually lowers the standard by which an officer may check immigration status. It's going to result in a whole lot more illegal immigration checks.
Well, that's certainly debatable. The newly tweaked policy has been in sort of a trial run over the past month, and the checks seem to be headed downward.
I don't think we've gotten to the point where the public understands. I don't think the public understood what we did in October completely. So then in April when we changed it, most people didn't realize a change had been made because they didn't understand the old policy.
I think Chief Deane, me, others are being pretty straightforward. I mean, the policy is what the policy is. The mandate now is on post-arrest, post-custodial arrest. That's the mandate. As far as what folks are going to say, in other levels of rhetoric, that's part of the fabric of a community, a local government, local politics, national politics.
Has the bar now been lowered that an officer just needs reasonable suspicion to check?
No, it's the same standard.
Explain the difference, because the chairman was pretty clear that the bar has been, he said the bar's been lowered.
He says that officers may investigate immigration status based on reasonable suspicion, for instance, even in a case where there is not an arrest or detention. What's your interpretation of that? Do you agree with him that this is a significant change? I see you pointing out another significant change. He believes this is the biggest change.
The most significant change that was made had to do with the stage at which the officers are mandated to make the immigration status checks.
You can see the confusion in this room and apparently on the floor. The chairman as well.
I don't think there's any real confusion.
I want to ask you, how's it playing out in the streets with your officers? How are they?
I think officers will see that that's a bright line. I mean, it's a real simple rule.
Can we go back to where he was talking about the lower standard? Are you saying the chairman's wrong about there now being a lower standard?
I'm not commenting on what the chairman said or didn't say.
We have two vastly different characterizations of this in the public arena right now. And you are the top law enforcement official with the reasonable suspicion standard prior to arrest that an officer may, if he or she has reasonable suspicion, look into immigration status. The chairman is characterizing that as a major, significant change that will result in far more people being questioned. You say it is not. Is that characterization wrong? I think the public needs to understand.
Interesting. Well, I can only answer the question in a different way. And the way I would say it is that we anticipate carrying out this resolution, very similar to the other resolution, but the mandatory portion of this has now changed to after arrest, when someone's physically arrested. So we're clear on that. And the prior to physical arrest, I don't anticipate more inquiries than I certainly don't anticipate more inquiries than we had conducted in the past.
I don't want to be a jerk, but if this is such a great policy, why wasn't it written this way in the first place instead of training everybody and then going back and amending it and then having to read it?
You're asking the wrong people.
Can I ask why everyone is so cautious not to contradict Chairman Stewart?
Well, he's our elected official. He represents the county as part of the board, and we're not looking to get into an argument or a debate about his statements.
Well, if I were a citizen trying to sort out which policy to believe is going to be implemented, the one that Chairman Stewart has described or the one that you and Chief Deane are describing, what would you recommend that I
would recommend you read the policy and make a decision for yourself.
This is the original policy. This is the revised policy. The significant change in the revised policy is the mandated area of immigration status checks has moved to the physical custodial arrest stage. Prior to detention or physical custody, the officer's authority to inquire about the immigration status is basically the same in both policies. Mm-hmm. The original policy says an officer may inquire into the immigration status prior to the establishment of probable cause if he has reasonable articulable suspicion as part of an initial identification inquiry to acquire an understanding of the facts, and then it goes on. In the amended policy, it says an officer may inquire into the immigration status prior to physical custodial arrest if he has reasonable articulable suspicion as part of an initial identification inquiry to acquire an understanding of the facts. But basically, that authority is the same in both of the policies.
For a long period of time, long before immigration became quite the issue that it is now, that was a tool that was in the patrol officer's toolkit if they needed to do things such as try to figure out who the heck somebody was. It's a federal right, so it exists. The board, the police chief, the county executive cannot change it.
So the thing we're paying so much attention to right now, at least when Chairman Stewart is talking, is something that was true before April 29th, 2008, and it was true before July 10th, 2007.
It was true at those times that you mentioned that officers had discretion to ask identification questions, and sometimes that could get into immigration status, yes.